Peace and blessings, everyone. Peace and blessings on this Monday. I am so excited that we have sprung forward. We literally have sprung forward. Daylight savings time took place this Sunday. And I woke up and I said, oh my goodness, I completely forgot because my alarm clock on my nightstand it's an old fashioned alarm clock. And so when I looked at the time, it just looked like it was the regular time. However, when I looked at my phone, I said, oh yeah, that's right. We had daylight savings time. So it's so weird to be sitting here talking to you all at 7:04 p.m. Eastern time on a Monday, and it's still light outside. It's so funny to me. I thought they were supposed to be getting rid of daylight savings time. They had been threatening to get rid of it for years, but I don't know if that's actually going to happen. It's so funny. So anywho, my name is Tamara T. Bush. If you all do not know me or if you are new to me, my purpose in the month of March 2022 is to provide clarity surrounding consumer law. There's so many things that affects us every single day, and I just want to make sure that we are all gaining the clarity that we need in order to be able to properly assert ourselves and make sure that we're not being taken advantage of, right? So that is the purpose for this. It's not just about building up your credit. It goes so much more deeper than that. So much more deeper than that. So we're going to go ahead and jump right in. Go ahead and share out this broadcast if you think that this information is going to be beneficial to someone. Go ahead and share out this information. And let's go ahead and get started. So I'm going to go ahead and share my screen. Place a 1 in the chat if you can hear me, if you can see my screen. Want to make sure that you all are getting the proper information and that you can follow along and look these laws up on your own, because I would like for you to also do the research to, just sort of aid your understanding and the clarity that I'm providing. Don't just rely on what I say. Definitely take the time out to go ahead and look this information up because it's going to help you to understand it in a way that is applicable to your situation. Okay, so we are going to go ahead and continue on with the Fair Debt Collection Practices Act, and that is 15 USC 1692. This particular subsection is going to be based on the validation of debts. And so again, you can do a Google search for 15 USC 1692, and it's going to probably take you to Cornell Law first before anything, which is also the Legal Information Institute. It may also take you to govinfo.gov, which is another resource that you can use to look up these laws. Govinfo.gov is very useful because you can literally go right to the website, type in the law, and it'll bring it up for you in a PDF format or a text format. So yeah, it's very useful as well. But I love Cornell Law because it gives you different resources inside of the text, and it also gives you the definitions of a lot of the words that's included in these paragraphs, and you can actually click directly on the word to gain the definition for the the sentence that you're reading. So I just want to do a brief recap from one of the other previous videos. I think it was the last video that I did where I spoke about who holds the liability. So under the FDCPA, what I went over, I explained that the debt collector actually holds the liability in the subsection. So any company that you're going after, just make sure that they fall within the proper definition of what a debt collector is, so that you can make sure that they are fully liable for violating the law and being willfully non-compliant to your requests and your demands as a consumer. All right, so validation of debt. So this is basically when you have a bill that you're paying, whatever that bill may be, and they're constantly coming after you for money, or you may have a collection agency or some sort of other debt collector that is trying to collect from you. As a consumer, you have the ability and you have the right to send a letter to the debt collector requesting that they validate the validity of the debt in which they are trying to collect. Okay, so this subsection is going to lay out what those instructions are, what you have to do as a consumer and what they have to do as the debt collector in order to satisfy the requirement under this subsection, right? Okay, so A says notice of debt. Within 5 days after the initial communication with a consumer in connection with the collection of any debt, a debt collector shall, unless the following information is contained in the initial communication or the consumer has paid the debt, send the consumer a written notice containing, right? So this right here is what the debt collector has to do, right? They have to give you the amount of the debt. They have to provide the name of the original creditor. They have to state who the debt is owed to, and they have to provide a statement. Now, this states that they have to do this within 5 days. Now, typically when you go to get a new credit card or you go on and you get a new loan, whatever that financial product is, the law basically states that they have to communicate certain things to you within 5 days. A lot of us thinks that it's within 30 days, but the law is clearly stating that it's within 5 days from the initial communication. Now, what is the initial communication? Your initial communication is the initial contact that you have with that debt collector, right? So if you go and you close on a loan on a Monday, that means that they have to have this documentation out to you no later than Friday. It has to actually be in your hands on the fifth day, right? And so what is a communication? Communication means the conveying of information regarding a debt directly or indirectly to any person through any medium. Now, if you have someone that is a debt collector that purchased a debt that was potentially discharged from another company, right? A communication can potentially be them reporting the debt onto your consumer report. You may not receive a letter, but you may just see something pop up on your consumer report that you're like, what is this? Why is this here? That is a form of communication. When a company is reporting something on your consumer report, that is a form of communication. They are communicating with you indirectly through another person. So what did we say a person was? A person is an individual, it's an entity, it's a trust. So you get the idea of what a person is. It doesn't mean an actual living, breathing man or woman. They're speaking specifically about a person. So keep in mind that companies communicate with you through your consumer report. It doesn't mean that they're sending correspondence directly to you. It doesn't mean that they have to email you, that they have to send you a physical letter, that they have to call you on the phone. They're communicating with you through any medium indirectly, right? So anything that you see being reported on your consumer report is a form of communication. So keep that in mind as we go deeper into this, into the section. Okay, so they have to tell you what the amount of the debt is, right? And remember the definition of a debt. And we went over this when we initially started going through the FDCPA. It means any obligation alleged. It says any obligation or alleged obligation. So what did we say that means? That means that you have the right to choose. Anytime that you see the word or in legal language, it means that you have the right to choose. So a debt means any obligation or any alleged obligation of a consumer to pay money arising out of a transaction, right? That is the definition of the word debt, right? The name of the creditor to whom the debt is owed. So what is the definition of the creditor? It means any person who offers or extends credit creating the debt or to whom a debt is owed. So remember, or means the right to choose. So when the law is stating that they have to provide the name of the original creditor, think about it for a second. In my previous videos, I discussed the reasons why some people identify themselves as the original creditor and other people do not. It really depends on the situation, and it depends on exactly what you're going after and what you want your remedy to be. So when they speak about who the creditor is, it says extends credit, right? We know that as the original creditor that we extend credit. But on the flip side of that, Are we receiving an assignment or transfer of debt? That is going to be the differentiating factor in how you determine if you are going to identify yourself as the creditor, or if you are identifying that company as the creditor, right? Because you know that as the original creditor, you know that when you go to sign on a document, whatever the thing is that you're trying to obtain, it's already paid for because your signature is the money, right? So the part that's missing from that equation is that you are not receiving an assignment or a transfer in debt of debt in default solely for the purpose of facilitating collection of that debt. So that's how you have to break down that definition in terms of identifying yourself as the original creditor. Remember, it's all in the definitions, okay? Number 3 says a statement that unless the consumer within 30 days after the receipt of notice disputes the validity of the debt or any portion thereof, right? So the law says that within 5 days, the debt collector has to give you the amount of the debt, the name of the creditor, right? And it's going to depend on which creditor information they provide. And then they have to give you a statement. Now, you know that typically you don't receive any documentation outlining this information within 5 days. I mean, you may receive some sort of electronic communication that gives you the amount of the debt, right? But is it giving you the name and address of the original creditor if the original creditor is not the company that you directly did business with, right? Number 4 says a statement that if the consumer notifies the debt collector in writing within a 30-day period that the debt or any portion thereof is disputed, right? The debt collector will obtain verification of the debt or a copy of the judgment against the consumer, and a copy of such verification of judgment will be mailed to the consumer by the debt collector, right? So now it says that the consumer has to send a written request. It has to send a written request. So let's think about this for a second. What does a written request mean? When I think about a written request, I'm thinking something that you actually either wrote out by hand, or you typed it out on a letter, and you mailed it. It says that you have to send a written request. So then what does that mean? If you call them and you request that they validate a debt for you over the phone, technically, because the law does not address phone calls, because we have to look and see what's not included. The law does not address phone calls. Technically, that means that they do not have to honor your request because you did not follow what the law states you are supposed to do as a consumer. It specifically states that the consumer has to send a written request within a 30-day period to the debt collector, right? So that they can provide the name and address of the original creditor if different from the other creditor, from the current creditor. So think about it. We are living in a digital age, right? And what I'm finding out is these companies are trying to get us to go digital. They don't really want us to deal with paper. They claim that they care about the trees and the earth and the atmosphere and all of these things, right? But do they really? Do they really? We're being, constantly inundated with requests to go digital. Oh, save paper. We'll give you a discount if you go on paperless statements. Save the trees. Go paperless. We get these types of notices all the time. Part of the issue is because there's a lot of information included in the fine print of our statements that if we read that information, it'll further properly advise us of what our rights are, right? The law clearly states a written request. A written request. So that's what we have to do. So if we're going after a debt collector for not satisfying their requirements under the law, okay, within 5 days, we have to make sure that we satisfy our requirements under the law in order to be able to properly state our claim. And I think that's where a lot of people get jammed up because they do not think that they were supposed to do anything as a consumer, but we have requirements just as well as the debt collector has requirements, right? Now, disputed debts. Okay, so what's supposed to happen once we notify the company that we have a disputed debt? It says here, if the consumer notifies the debt collector in writing within 30-day period described, right, where the consumer is requesting the name and address of the original creditor, the debt collector shall cease collection of the debt or any disputed portion thereof. Cease collection of the debt. Okay, so what does cease collection of the debt mean? What does that mean? That means that they can't call you, they can't send you a letter. That also means that they cannot report the debt to your consumer report while that debt is actively being disputed. That means that they have to remove the item from your credit report during the time that that debt is being disputed. Now, you know that ever since COVID, when the CARES Act was released, the CARES Act entitled us to receive a free copy of our consumer report once a week. Prior to that, we could only get a free copy of our consumer report once per year, or if we received an adverse action letter from a creditor denying us credit. Those are the only circumstances under which you can get a copy of your consumer report. Now we can actually go and get a copy of our consumer report every single week, meaning every 7 days. So if you send a debt collector a letter stating that you dispute the validity of that debt, they are supposed to immediately remove that item from being reported on your consumer report, because them continuing to report means they are communicating with you. And if they are communicating with you, that means that they are actively trying to collect a debt, even though they're communicating with you indirectly. So if you go to pull your credit report on week 1, you send your debt validation letter to the company. You send it certified mail, because you always want to send your stuff out where it's being tracked, right? You send it certified mail. You know that they received it on day 3. So when you go to pull your consumer report by week 2, and that item is still reporting, that is a violation of this subsection, because they are no longer supposed to report that item on your credit report while it is actively being disputed. It's a violation, period. It's a violation, right? Okay, so let's continue on. Until the debt collector obtains verification of the debt or a copy of the judgment or the name and address of the original creditor, and a copy of such verification or judgment or name and address of the original creditor is mailed to the consumer by the debt collector. What does it say? Collection activities and communications that do not otherwise violate this subchapter may continue, but any communication is a violation, right? During the 30-day period referred to in subsection A, unless the consumer has notified the debt collector in writing that the debt or any portion of the debt is disputed, or that the consumer requests the name and address of the original creditor. So this is basically just reiterating the previous sentence. But what does it say? Any collection activity and communication during the 30-day period may not overshadow or be inconsistent with the disclosures of the consumer's right to dispute. Okay, so basically what they're saying here is that they have to cease the collection of a debt. They have to cease the communication of the debt, but they can only communicating when they are notifying you that they're basically addressing your dispute. That's how I interpret that. Okay, letter C says admission of liability. So basically what this subsection is saying right here, it's saying that if you fail to dispute the validity of the debt, that does not mean that you agree, and it's not an admission of liability by you of the consumer. The failure of the consumer to dispute the validity of the debt under this subsection, this section, may not be construed by any court as an admission of liability. So don't fret. Just because you didn't notify them that you dispute the validity, it does not mean that you admit or acquiesce to the debt either. So as a consumer, you are still being protected, right? And legal proceedings of communication in the form of a formal proceeding in a civil action shall not be treated as an initial communication. Okay, so when they sue you or you go to sue them, that cannot be treated as initial communication under which they have to provide the information being requested within 5 days, right? That's basically what that is saying. All right, this is for validation of debts. So again, pull your credit reports every single week or as often as you can, so that if you are actively disputing a debt, you can see what's going on. You can actively see what's going on. Now, let me just say this. If you have someone that's working on your credit, there's a lot of things that a credit repair company can do for you, but there's a lot of things that a credit repair company cannot do for you, right? A lot of credit repair companies require you to have a credit monitoring, and those credit monitoring services will only allow you to pull a copy of your report once a month. That's included in the service, right? You, as the consumer, should be actively involved in the credit restoration process, right? So you should be actively pulling your reports every single week because you have to contribute to the process. And it's very important for you to learn to properly assert yourself in your own situation, right? Because everyone's situation is different. So this is why templates do not work. Handwritten letters to these debt collectors and handwritten letters to these consumer reporting agencies is what is going to get you the result. Or if you're typing a letter, you can't use a template. You have to switch up the language and make it valid to your specific situation because everybody's situation is different. So basically, when you're going after these companies, you're basically telling your story. What are the facts? What actually happened? What are you requesting? What are your list of demands? You want to be as specific as possible. Now, anytime that you are looking at the validation of debts, you're looking to get information from a company. One of the things that we need to pay attention to is the fact that they need to provide the name and address of the original creditor if it is different from the current creditor. This section right here is very, very, very important. Because if you are the original creditor, you know that they are never going to admit that you're the one that lent the money. Because remember, we spoke about 18 USC 8, obligations or other security of the United States defined. This section right here basically tells you that all debts, public and private, is the obligation of the United States. So if you're going to a debt collector and you're requesting validity of that debt, they're supposed to tell you who the true original creditor is if it is not the current creditor. So we always have to keep this subsection in mind because anytime that they come back and they state that the debt has been verified, you know that that's not true because you know that all of the obligations is and securities are obligation of the United States. So this is just another angle that you can go after them for because you know that this is not your debt. We should not be paying these bills anyway. The law clearly states that these are not our obligations, right? So this is just something else that we have to look at. So definitely pay close attention to anytime that you're going to request validation of debt. I'm going to skip down to 1692J, furnishing certain deceptive forms. I'll close out with this. Now, if we know that all obligations belong to the United States, then why are we receiving a coupon every single month in the mail, right? When you look up the definition of a coupon or a statement in Black's Law Dictionary, that definition is basically showing you that the coupon is the money and if properly endorsed will take care of the debt, right? So why are you receiving a monthly statement? It says, it is unlawful to design, compile, and furnish any form knowing that such form would be used to create a false belief in a consumer that a person other than the creditor of such consumer is participating in the collection of or in an attempt to collect the debt. We believe that we are participating in the act of debt collection because we believe that the debt belongs to us. But if the law is stating that all debts, public and private, is the obligation of the United States, then any statement that you receive in the mail every single month is considered a deceptive form because it is literally creating the false belief that you owe money. It's creating a false belief, right? Like literally creating a false belief that you are participating in a debt collection when you are not participating. Okay, so it's very important that we know and understand whose obligation did the debt belongs to, who has the obligation to pay this debt, because it's not us as a consumer, right? Any person who violates the section shall be liable. They shall be liable under 1692K. And so on my last video, I specifically went over who holds the liability. And in this section, it is the debt collector, because it clearly describes any debt collector who fails to comply. It doesn't say any consumer. It says any debt collector who fails to comply, right? That they will have to pay any actual damage sustained, right? And in the case of any action by an individual, such additional damages as the court may allow. Now, the thing of the matter is that we have to be very, very, very cognizant of what that actual damage would look like. Now, if you have a collection agency that's coming after you for the collection of a debt, they put something on your credit report, you know that it's not valid. And so because that collection item is on your credit report, you go to apply for a loan and you get denied, that is considered an actual damage. If you go and apply for a $50,000 loan and you got denied, that is an actual damage because you didn't get the loan. And so you go after them for the actual damage, not just $1,000. I want the actual damage sustained. So your damage to me was the fact that you reported something on my credit report and I got denied because of it. I didn't get the loan that I applied for. That's an actual damage, right? These are real numbers. Civilly liable. All right. So I just wanted to take some time to go over that subsection of the FDCPA. Again, this is 15 USC 16, which one is this one? This is 15 USC 1692, which is the FDCPA. Back to it. All right, and so we left off on the validation of debts. The validation of debts. So in my next video, I'm probably going to go over, I'm going to circle back to the Fair Credit Reporting Act because that's really a hot topic with people. And so we're going to go over, probably going to go back over the block and remove that I went over before, because I want to make sure that everyone is absolutely clear on what's supposed to happen when you send a letter to the CRAs asking them to validate a debt. We have to go over that again because I get questions on that all the time, more so than the FDCPA. But when you go through the FDCPA, just pay attention to the titles of the subchapters because it literally is what it is, right? We're being harassed, we're being abused, we are being lied to, we're being furnished with deceptive forms all the time. There is unfair practices that these companies are doing to us. They improperly validate debts. They tell us that we owe money that we don't actually know, right? They illegally take us to court. How are you going to take me to court for an obligation that's not mine? It's amazing. So definitely drop your questions in the chat. I will gladly answer any and all of your questions. I want you all to continue to put your city and state that you're tuning in from, because we're going to be looking at doing some events in some of these cities and really, bringing the people together so that we can continue to provide clarity on these matters. But definitely let me know if you have any questions. So again, my name is Tamara T. Bush, and I am providing clarity on consumer law. Please know that I am not an attorney, nor am I providing legal advice. I am simply providing clarity to these laws as I understand them as well. So you all definitely have a great evening, and I will see you in the next video.